Hello, my name is Thanos Panagiotou and I'm sending this presentation for the seminar in medical malpractice. Unfortunately, I didn't manage to be there, to be present, but I hope that the lecture will be interesting. I'm a PhD candidate in medical liability at the Aristotle University of Thessaloniki. I'm also a part-time instructor teaching business legal issues at the American College of Greece Degree, where the particular recording takes place, at the library of the American College of Greece Degree. Today, together, I hope that I will not be boring, because I assume that you are tired because it's the last lecture of the day. I think there is one more, but I think that the topic is very interesting in the field of medical liability, because as any other science, legal science needs to follow other sciences in their development when both sciences, medical and legal, have their aims crossed and the lines for science crossed. So, the topic of my lecture will be medical liability and the role of clinical guidelines in medical liability. First of all, I would like to mention that the key problem in most medical liability systems, the fault-based ones, is that the concept of fault and malpractice and the relevant standard of care based on which the doctor's conduct, professional conduct, will be evaluated is not straightforward. Basically, it's a landscape in the mist. The criteria adopted by the medical science, by the legal science, are vague, and especially the fact that the judges who have legal background and not medical background are called to evaluate and judge the professional conduct of doctors based on vague criteria makes the task difficult and leads to, in some cases, inaccurate decisions. One of the problems is also the inexact character of medical science. Medical science is something, medicine is something between between art and science, and that's why we cannot say for sure, we cannot be accurate in all the cases regarding whether the doctor was at mistake or not, whether we have malpractice or not. In the Greek legal system, the criterion, the basic criterion for the standard of care is that the doctor must have shown the conduct that the average prudent doctor of the same specialty would have shown under the same circumstances. So as you see, the criterion is really vague, because we must try to find out what the average doctors, or the majority of the doctors in the same specialty, would have done based on the same circumstances. So this vague criterion, and especially in fault-based jurisdictions, in jurisdictions where the medical liability is based on fault, so in order to accuse a doctor and provide compensation, we need to make sure that the doctor's behavior did not conform, was not in line with the standards of his profession, with the rules that the medical profession imposes to doctors. So we need to make sure that the doctor was at fault, that the physician did something inappropriate, did something that was not proper with the standards of his profession and of his specialty. One way, so the legal science is trying to find ways to clarify the standard of care. One of these ways is the use of clinical guidelines in the field of medical liability. First of all, before discussing the structure of my presentation, will be, first of all, I will make a few comments regarding evidence-based medicine and clinical guidelines, and then we will see what are the pros and cons, the advantages and the disadvantages of using clinical guidelines as the key criterion for the establishment of fault in medical liability, for the evaluation of the doctor's conduct. And finally, we will make some conclusions in order to be able to look at the future and see whether clinical guidelines in the future could be possibly the golden rule, the magic bullet for medical liability. First of all, what is evidence-based medicine? Evidence-based medicine is basically the reasonable use of best evidence of medical research in order for physicians to make decisions regarding the care of individual patients. This is the Institute of Medicine's in the US definition, and generally the basic difference between evidence-based medicine and traditional medicine is that evidence-based medicine is based on medical research and not on the personal experience and the customs of the medical profession. Of course, during the last decades, in many countries and many health systems, clinical guidelines, which in some cases incorporate evidence-based medicine and the results, the outcomes of clinical research, are being used by hospitals, clinics, professionals, medical professionals, etc. What do we mean by clinical guidelines? Clinical guidelines are systematically developed statements which assist doctors and patients make decisions about the appropriate healthcare, about the services that the patient will receive under specific clinical circumstances. So the big question is whether clinical guidelines, which are statements that are made in order to help doctors make their clinical decisions, and taking into account that these decisions are analyzed in the court in medical liability cases in order to determine whether the conduct of the doctor was professionally okay, was professionally proper, was respecting the standards of the medical profession or not. So in medical liability cases, what we do is that we analyze the conduct of the particular physician and we try to find out, using medical experts or testimonies, etc., expert testimonies, we try to find out whether his conduct was in line with the standards of the medical profession. So, if we accept that clinical guidelines are one of the tools that physicians use in order to make these decisions, the question is whether we could maybe make clinical guidelines the major criterion for the evaluation of the physician's professional conduct under particular circumstances, and so whether the use of clinical guidelines can make that landscape in the mist that we mentioned before of medical liability and fault and the evaluation of physician's conduct a straightforward process. Because for both judges and lawyers and patients, it would be a step into the right direction to be able to just use clinical guidelines, to just be able to compare the doctor's conduct with the suggestions, recommendations of clinical guidelines, and be able to have a final outcome and decide whether his behavior, his conduct was faulty or not. But the question is that, are the things so simple? Is it so simple to just take one guideline, compare the behavior of the doctor with the guideline, and decide whether his behavior was malpractice or not? The truth is that the things are not straightforward. There are some advantages regarding the use of clinical guidelines as the major criterion, but also there are also many disadvantages which currently hinder the application and hinder basically the use of clinical guidelines as the major criterion in medical liability cases. Of course, as we will see, courts start using clinical guidelines in the medical liability field, but there is still a long road ahead until we make guidelines the golden rule based on which the doctor's conduct will be evaluated. Let's see the advantages of clinical guidelines. So let's say that we reform medical liability laws and we decide to make clinical guidelines as the basic criterion for the evaluation of the physician's conduct. Let's imagine that we decide to incorporate clinical guidelines into the standard of care, and we decide to rephrase the standard of care and say that the doctor is not negligent if he has followed the relevant clinical guidelines. First of all, clinical guidelines have the one advantage of clinical guidelines is the improvement of quality of care. Clinical guidelines can also ensure consistency of care and discourage ineffective clinical practices. Another advantage is that if we decide to make clinical guidelines as the major criterion for medical liability, the care, because most physicians will follow clinical guidelines because of the fear of litigation, and because they know that by following clinical guidelines they will be protected from a legal point of view, then we have the advantage that the care provided to patients at the same country or different countries is consistent, so that most patients receive similar clinical care. Clinical guidelines are also good for the physicians themselves because they may help them improve the quality of clinical decisions. And so they have the prospect of incorporating the latest clinical evidence and clinical research outcomes to clinical practice. So we will basically be able to apply clinical care models, to use clinical care and practices that have been proved effective by medical research, latest medical research. On the other hand, doctors can be discouraged to use practices that have been proved ineffective based on scientific research, even though tradition and medical custom had adopted these practices before. With respect to the legal profession, I think this would be, if we decided to make clinical guidelines as the basic criterion for the establishment of fault in medical liability, the most important advantage is that we would find an attractive alternative for the uncertainty regarding the standard of care in existing clinical practice variations. The biggest problem, in my opinion, in fault-based systems, as we have mentioned before, is that people with no medical background, judges and lawyers, try to evaluate and are called to evaluate the professional conduct of physicians, of representatives of a very specific and quite tough science and complex science, and without having the relevant medical background. And so the problem is that most cases, most trials end up being a battle of experts, having experts from one side and the other side, and then the judge is called to decide and to choose between two different analyses regarding the scientific aspects of the case. So imagine a judge having to decide which expert is correct and which is not correct, and then trying to find whether there was a fault, there was malpractice or not. So clinical guidelines have the prospect to demystify the clinical decision making. So if, based on guidelines, the doctor's conduct is capable of being analyzed into specific steps, then even lawyers or judges with no legal background may be able to evaluate and have a real understanding regarding the professional conduct of the specific physician. Another advantage would be that if guidelines make the decisions and the resolution regarding medical liability straightforward, that generally medical liability decisions will be more consistent and more accurate. Because even in many countries, and in Greece, in the US, we see that even regarding similar cases, you may have different outcomes. So you may have two cases, one being resolved in 1999, another one in 2010, with similar facts, and the judges reaching totally different decisions. So the use of clinical guidelines may make the whole process more consistent and more accurate, and because the whole process and the resolution regarding fault and malpractice and the standard of care will be more straightforward. So that would be a major advantage from a legal point of view, that things will be simpler for both judges and patients and lawyers. But the question is that, is it so simple? No, it's not so simple. These advantages would be reality only if the issue of guidelines was without flaws. Only if guidelines were a part of the practice of medicine and were practiced by all physicians. But the truth is that there are inherent problems in guidelines which currently hinder their use, their total use in medical liability. First of all, many guidelines are developed not based on evidence, but based on consensus of a group of expert clinicians, without explicit reference to research evidence. And so the question is that, can we judge a particular doctor based on a clinical guideline which was not based on evidence, or research evidence as it was supposed to, but it is just a consensus statement, an agreement between experts in the relevant field that have agreed that under particular circumstances for these diseases the doctors must follow the following steps. And so the problem with expert consensus reports is that basically there is no scientific research and no scientific evidence on the background. And another problem is that the whole process would probably be very similar to the current process, the battle of experts, because the patient may bring one guideline with expert consensus, and the doctor may bring another guideline with expert consensus from other experts. And so the problem is that we end up having the same process, the same problematic process known as the battle of experts. Another disadvantage of expert consensus guidelines is that the committee creating these guidelines has specific biases, and the most important of which are financial biases. It is true that, and it is commonly accepted, that financial ties exist between panel members and industry. And so the question is, can we judge a doctor, or can we determine and resolve the case and decide whether there has been malpractice or not based on specific guidelines where the resolutions, the recommendations are influenced by financial biases? Another problem is that even if the guidelines include scientific evidence, that evidence is often lacking, misleading, or misinterpreted. And the problem here is that, let's assume that the guideline is supported by scientific evidence. Let's assume that we have an evidence-based guideline. What if that piece of evidence is not satisfactory? What if the study based on which the guideline was created was not well designed, was not inappropriate? Can we then generalize the outcome of the guideline and the recommendations and judge the particular physician in a medical liability trial based on this guideline? So the flawed clinical guidelines can lead to the opposite result, can harm both practitioners and patients. So even if we have an evidence-based guideline, we need to make sure that the evidence behind this guideline is accurate and that the study was well designed. So here we have another problem, that there are no commonly accepted, commonly used by everyone ways of guideline development. So we need to make sure that we have a specific process for guideline development accepted everywhere, and after reaching an agreement regarding the specific guideline development process, then we can see whether guidelines can be used as a major criterion in medical liability cases. Another problem that hinders the total application of clinical guidelines in medical liability is that patients' needs are not always the only priority in making the recommendations. So, if we have a guideline that its major purpose is to help control health costs, or to protect special interests of doctors, or interests of risk managers, or interests of politicians. So if, and this is the case regarding many guidelines, if the patient's needs and the provision of the optimal care is not the only aim of the guideline. If the guideline also aims at controlling costs or protecting the interests of physicians, let's say, because the physicians, the special physicians writing the recommendation want to protect the interests of the specific specialty in order to enhance the role of the specific specialty in this medical field. In this case, can we really judge the conduct of the specific physician based on a guideline that was made in order to take into account not only the patient's needs, but also the control of health costs and the protection of other special interests? So that type of guideline is in contradiction with the idea of tort law, which is basically to deter unsafe practice and to determine whether in this case the patient was actually harmed or not. So our focus in tort law is on the patient, but the focus of these guidelines is not only on the patient. So we cannot really use this type of guidelines as the ultimate criterion for medical liability. Another problem is that in some cases, in most cases, guidelines are not flexible. They're general, they're vague, and they cannot take into account, and they do not take into account the circumstances and the preferences of the particular patient. So the big question is that, can we really take one guideline and can we really adopt a one-size-fits-all approach? Can we really use a guideline in order to judge the medical care provided to different patients with different medical history and background? That's another problem, that guidelines are not patient-specific. But so we have on one hand a guideline that was developed in order to suggest the optimal care for the average patient, but we have a case, a trial taking place, and in the trial we focus on the care provided to the specific patient. We do not judge the average patient, we try to see whether the care was optimal for the specific patient. So the big question here is that how can we really be able to combine these two elements, combine the general character, the average patient approach of clinical guidelines, and the patient-specific approach used in the courtroom. Another problem is that there are too many guidelines, even for the same topic. And that's a problem, because if we do not really decide to have one guideline commonly accepted based on evidence for each disease, for each medical condition, then we will end up having something similar to the battle of experts. We will have contradictory guidelines, and we'll have the patient using one guideline in order to prove that there was malpractice, and the physician using another guideline for the same condition in order to prove that he followed the guideline and there was no malpractice. So, because there are too many guidelines and in many cases contradictory for the same medical condition, then that would really create problems if we decided to use medical guidelines as the basic criterion for medical liability. Another problem are outdated guidelines. Medicine changes really quickly, and the evidence behind clinical guidelines changes really quickly. The problem is that most guideline developers do not use processes for guideline update. Some of them use, others not. So the big question is that if there are no specific standard processes for the continuous update of clinical guidelines based on the latest research, can we really use clinical guidelines as the major criterion for the establishment of fault in medical liability cases? Can we use outdated guidelines in order to judge the professional conduct of the physician? Another big problem is that physicians do not use guidelines. Research has shown that many physicians in many countries do not use clinical guidelines. Some of them are unaware of clinical guidelines, others are non-compliant. So some physicians do not know that these guidelines exist, and also others they know the existence, but they do not comply with clinical guidelines. So the question is, how can we really use clinical guidelines as a criterion for for medical liability, when we know that only a small minority of physicians actually use clinical guidelines? And this is a very significant problem, because whether the use of clinical guidelines in medical liability really depends on the position that the medical community and the role that the medical community has given to clinical guidelines. If clinical guidelines are practiced by a small minority of physicians, then if we try to incorporate clinical guidelines in the standard of care, like for example in Greece, we say that the physician must have acted as the same way like the average prudent doctor of the same specialty. If only few doctors use clinical guidelines, we cannot say that following a clinical guideline was in line with the practice of the average physician, because the average physician means that the majority of physicians use the specific practice and would have acted in the same way. So the position, the acceptance of clinical guidelines within the medical community is crucial regarding the acceptance and the use of clinical guidelines in the medical liability field. Another problem is regarding the protection of professional autonomy and discretion, that many physicians claim that we cannot practice cookbook medicine. Medicine is a science, but is also an art, and so we cannot really, we feel insulted, and we feel that this is an insult to our autonomy and an intrusion to our freedom to practice medicine based on our best judgment. And in the end, we are the ones that we know the special features of the particular patient, and we cannot just follow some steps prescribed and described in the recommendations of guidelines. Another problem, which is quite significant from a legal point of view, is to try and find out what do guidelines incorporate? Do they describe the best available care? Do they describe the best optimal care or the minimally acceptable care? And this is very significant, because if we accept that they represent customary care or reasonable care, then they can be incorporated in the standard of medical care. But if they approach the ideal standard of care, then we have the problem that there is the danger of unduly penalizing physicians whose care, even though it's reasonable or customary, does not satisfy the professional guideline for the specific patient. So, if we accept that clinical guidelines are the ideal care, are we just raising the standard and unduly penalizing physicians whose care was reasonable but was not ideal? Because in most, nearly all, fault-based systems, we do not ask the physicians to do the ideal. We need to make sure that they acted the same way, they provided reasonable care and the same care that the average physician, the same specialty under the same circumstances would have provided. So that's another issue. Now, the conclusion and the future. I hope that there was a problem with the camera. This is the last part, a few minutes. I hope that everything is okay. Regarding the conclusions and the future of the use of guidelines in the medical liability field. Generally, if we continue having guidelines, they need to undergo major changes. We need to make sure that these major changes actually take place before starting even thinking of making guidelines the major criterion for the establishment of fault in medical liability. First of all, we need to reform the guideline development process. We need to make sure that the guideline development process is accurate, is consistent, and is based on the standards of the medical profession. We need to make sure that the evidence produced and incorporated in guidelines are of high quality. In order to start evaluating the physician's conduct based on guidelines, we need to make sure that guideline development is centralized in order to make sure that there are no contradictory guidelines that may confuse physicians. We also need to make sure that there is no one-size-fits-all approach, that clinical guidelines need flexibility. They need to incorporate the element, the idea that each patient is special, that the feature of each patient the characteristics of each patient need to be taken into account. So guidelines need flexibility, and we should understand that guidelines are not supposed to be guides, are supposed to be guides and not rules. So at that point, we cannot just use guidelines as the major criterion, and we will probably not be able to do it in the future. If the medicine, the medical science reaches a point where everything will be decided by guidelines, that everything can really be controlled, and that we will be able, if we are able to know the specific outcome for the specific patient and to know the outcome for every patient in the context of his medical care, then we may be able to treat them as golden rules. But at that point, clinical guidelines need flexibility and need to be taken into account by physicians as guides and not as rules. And that's why we cannot consider them as the major criterion, as the only criterion for the establishment of fault. We can take into account guidelines, and the more clinical guidelines are incorporated into everyday practice, the more will be the pressure, the higher will be the pressure to the medical profession, to the legal profession and the judges and the lawyers, in order to start thinking start contemplating on the ways clinical guidelines and their concept will be incorporated into the standard of care. Thank you very much. That was a presentation. I hope you enjoyed it. I know it was a long day. Again, I really apologize for the inconvenience with the video. We discussed a contemporary topic. Clinical and medical science are two really exciting sciences, and medical liability is one of the fields where each science meets the other. And so it's really tough to see how developments in one science, the medical science, and the developments are evidence-based medicine and the rising use of clinical guidelines, how the developments in one science influence the way the other science, the legal science, treats medical liability cases. So that's a topic that will certainly be of great interest in the future. Thank you very much and have a great day.